Good day, everybody. This is Ray Sneishavel from the law firm Garris Horn. Today we have another episode of Garris Horn Insights. Our guest today, we're very fortunate to have, is our partner, Melanie Feliciano. Melanie has done many things in her past, we're very happy to have, of course, as a partner. Been with us for a few years, I think. But her specialty in the past and things we're going to talk about today is really document compliance. Lenders need document compliance. And I will say increasingly in the state examinations I've seen for some clients, doc compliance is kind of bubbling up as an issue. So who better to talk about that than Melanie? Melanie, you've been there and you've done that. Tell us something about yourself, a little bit of your background on that, and let's talk doc compliance.
Ray, thank you for having me today. I'm happy to be here. So prior to Garris Horn, I was with a premier document preparation and automated compliance company. I was in charge, among many other things, of ensuring that the forms and disclosures that appeared in the various loan packages that this doc prep provider provided were compliant with applicable federal and state laws. So I did a lot of transactional work as well, negotiating and preparing documents with partners of DocMagic and customers as well. But in particular, with respect to document compliance, I can recall, a number of customers who had the mindset that it was the responsibility of a doc prep provider to provide compliant disclosures and be responsible for what the documents that appeared in a particular loan package that they ordered. And one particular customer many years ago had been cited by their state regulator for not having a disclosure in a loan package to the borrower. And they immediately looked to us, the document prep provider, and asked, why was this document missing? It should have been there. And of course, we had it in our forms library, and we had it in another package that this customer didn't order. And we were able to demonstrate that this, disclosure was available, but the customer could not understand why. They felt that it was our responsibility as a doc prep provider to make sure that disclosure had been ordered or in their particular package. Well, so the lesson to be learned there is that customers, as licensees with state regulators or with a federal regulator, are responsible ultimately for providing the correct disclosures to borrowers based on the loan transaction. And if you look at statutes and regulations, they don't say the doc prep provider must provide this disclosure to the borrower.
Right.
It really is the licensee, right? Whether it's a mortgage banker, a broker, financial institution of, regulated by, a federal agency. But anyway, in the end, the good news is that this customer was able to negotiate with the state regulator, provide the required disclosures to the borrowers as a corrective action. And if any fees in that disclosure had been misstated, they were supposed to provide a refund or make restitution to the borrowers. So, it's important that sometimes document compliance is overlooked, but it's an important aspect of a compliance management system, because you could be subject to fines and penalties if you're missing a required federal or state disclosure. And you know, typically insurance carriers won't insure the insured against fines that are imposed
Correct.
by regulators.
Well, I find that to be, and I appreciate you saying that. I think sometimes there's a disconnect, having done this a long time, dealt with lenders, being on the lender side myself, general counseling many times. Who's responsible for the doc set when something's missing? I think it's a great question. And you've established here that it's, look, we're a library, but we're not, you have to check out the right book, right? Dewey Decimal System. You have to check out the right document and put it into your system yourself. We are not guaranteeing that it gets in there. As a doc provider, I can see that. That means then a lender is going to have to take time and resources to make sure that they have the right documents in place for the state. And I know this is tricky because sometimes it's the transaction type, whether you're a lender or a broker or maybe license type. There's different licenses in states. So the lender, I guess, is in a better position to determine that. So I think that's good information. I think that's good motivation, certainly for doc compliance. So
Yeah.
what else should they be focusing on looking at? What do you think?
Well, I want to go back to what we were just talking about, just to highlight something important that a lot of, you know, people may overlook, and that is, you know, with doc prep providers, LOS providers, they're using sophisticated technology, right? And you don't have the employees of these companies manually reviewing customers' packages based on what they order. Typically, you know, customers are entering loan specific data into their LOS systems or LOS providers, and that data is hitting the servers of these doc prep companies, and based on the data, they return a doc package. And that's why, because no one at an LOS or a doc prep provider can manually look at these, it's very important for customers to ensure that all of the documents that they're supposed to have during a particular phase of the origination process is provided to the borrower.
Okay, thank you. So that's, I guess, a key, I think, motivation to make sure we get it right. And not always easy to do, I admit, not always easy to do.
Right.
With, you know, everyone, and especially in heyday when you've got a lot of volume, you're just throwing stuff, you're going into a state and you hope that everything is going to be there. So what else can you tell me insofar as, you know, when we're looking at docs, and now let's say we're at a lender's getting their resources, their compliance professionals internally, let's say, or something, looking at the documents, doc sets. You know, what are we looking at? What should we be focusing on? I mean, everything, data points. I mean, look, documents, let's be clear. Documents are not just about the disclosure. It's about that you, number one, capture the information. Number two, the information is being able to be moved or data in the data plot somewhere. Three, it's plotted in the right place in the document. And four, ultimately the number is correct. The data is correct, right?
Absolutely.
So it's not just, yeah. So tell me about that. Tell me about how we go about tackling a disclosure compliance process.
Well, it's made very easy these days, like you said, because data is simply entered into a system like an LOS and the documents spit out. But what happens in the way that doc prep providers usually structure the return of these documents is based on a number of things. One, the license type of the customer. Are they federally regulated? Are they state regulated? And remember that there are some states that have multiple licensing schemes, like California. I think there are three licensing types under which you can originate a residential mortgage loan. And depending on the license type, there are unique disclosures that must be provided to the borrower. But you also have to consider the timing requirements of a disclosure. Where are you in the loan origination process? Is this within 3 days of having received or submitted a completed application? you need to know what documents are triggered, within those 3-day periods, like the loan estimate, and the other disclosures. So it's important to know what the timing is in the origination process, what federal disclosures are required. We mentioned the state disclosures as well, but also if you're planning to sell to a particular investor, that investor may have their own unique disclosures that need to be provided to the borrower. They may not be legally required, but they may be like a welcome letter. And in order to sell to the investor, maybe if it's a second lien loan, they have their own unique promissory note and security instrument. So it's important to be aware of those things. The GSE requirements, of course, there are underwriting criteria that you have to be aware of. Agency loans, government loans, for example. Do you have all the FHA disclosures in the loan package? For initial disclosures or pre-closing or at the closing stage. And then you talked about the population of data. Are they appearing in the right place? Well, there are some disclosures that require calculations to be made and, a number to be put in. So are the correct data points being collected to make the correct calculations and dynamically populate that onto the form? Those are things that you have to consider as well. And finally, I think the origination type of the customer is important. Are they originating a loan as a lender, or are they doing that as a broker? There are broker required disclosures, as you know, that need to be provided. And if you are a customer, you need to make sure that if you're originating a loan, not as a broker, those broker disclosures don't appear in your lender package. And it's important to note that by providing superfluous documents or documents that are not required to be in a package, you might potentially be creating a UDAP issue.
Yep. I agree with you. So, I've seen a few things. First of all, I think certainly with the state of industry, the trend is some people are going from lender to broker, and they have to understand that there's broker disclosures that while you may have been a lender for 15 years, your doc set doesn't really match in that state as a broker. Don't forget that you have to get that disclosure. Or if you're doing both, we're going to be a broker, both the broker and the lender. Great. Then in this doc package, you need to get a broker disclosure, not the lender disclosure. So I think that's really important. I've seen some confusion there in the industry currently. I've also seen, and this is if it creeps up, I don't know to what degree, but it's ARM loans, right? And ARM loans are its own world. So I've seen situations that they throw the switch, they do ARM loans, but they're not. The document might be spitting out, but the data shows that the margin is 0 when it was really supposed to be, 2.5 or whatever, right?
Right.
So the quality of the information, the data getting to the document could be a challenge. And if we make assumptions, we've been doing great. Well, yeah, we've been doing almost 15 years of fixed rate mortgages. Going back to ARMs, don't forget there's a lot of moving parts in those between the different disclosures you need and the data that goes with it. So it's not wrong to do it, just be aware of it. So but I guess for that much, I mean, I have a sense, I'm gonna ask you a question. I have a sense to know the answer to this. Once I look at my doc set, I'm gonna pose it this way because you know where I'm going with it. Once I have the doc set and I've checked it off and this state is good, I don't have to ever look back at it again, right? Everything's fine. It'll be that way all the time. What are your thoughts? I know it's a total setup. You can spike it. Go ahead.
Well, I don't think you have to look at it all the time, but because laws and regulations, statutes and regulations get updated all the time, right? They're amended, new regulations are passed, new statutes, etc. So you have to conduct routine maintenance and build this into your compliance management system. I mean, I think you raise a good point, and in my past experience, I noticed that the customers who had a very good compliance management system would do this when they were, first onboarded with a doc prep company like my former employer. They would run sample packages and make sure that the federal and state disclosures, the legally required documents like the note and security instruments were appearing in the appropriate loan packages. If based on their license type, based on the loan program or the loan type, and their origination type. So they would make sure that everything was in order, but they would routinely or periodically do spot checks to just make sure that the documents continued to appear there, and especially to make sure that most investors won't purchase a high cost loan, correct? So they would just make sure that the loans that they were originating were not crossing that threshold to a high cost loan, or if they didn't want to originate higher price mortgage loans, they would just make sure that they didn't cross into that territory. Or if it was an HPML, they just wanted to make sure that they maybe had escrow, depending on if it was a jumbo loan, for example, escrow open for that. So anyway, they would conduct periodic maintenance. And as they launched into new states, for example, as they acquired licenses in other jurisdictions, they would repeat that process all over again, but routinely spot check, make sure with their doc prep provider too, that they understood what that doc prep provider's process was for updating loan documents and disclosures based on changes in the law, based on updates to investor requirements, that kind of thing.
Yeah, the one I've experienced probably more than one occasion is changes to the underlying technology, an update to the LOS or something, and of course maybe customizations that were done by the company to say, hey, we're going to do this. Can we start? Let's create a flag and we'll do this. And don't realize that the programming, the spaghetti in the programming triggered something in some random state disclosure that no longer fires. And it's like, why did that happen? Well, it happened when this new rollout came out from whatever product, could be whatever, and it derailed what was otherwise already hard coded for the documents for some reason. And I don't know that I don't know technology very well, but I do know it was the spaghetti. So the spaghetti programming, whatever it was, created some kind of a matrix glitch to the point that a disclosure that we've always done that. Well, it hasn't been happening for the last 2.5 months. Why? It's like, well, we don't know, probably because of go back and fix it and something caused a trigger. So I've seen that too. So don't get comfortable, what I'm hearing, with your doc sets just because they're there. So what do you think, as we close this out, what do you think our takeaways are in kind of in managing documents in a nutshell? What are the things that we should be thinking about and looking at? And I'll share mine as well, if I could.
Well, if you're working with a doc prep provider, understand what the respective rights and responsibilities are, the doc prep provider and you as the lender or broker, and understand, like I mentioned earlier, what their procedures are for updating. For example, when the TRID disclosures came out, I think a lot of customers were wondering, how soon am I going to get to see this and test this? They didn't want the TRID disclosures in their packages on day one, not having seen it, and just played with it a little bit, to see how
right.
It would be reproduced. So I think it's important to understand what a doc prep provider's procedures are for updates, but just be aware of your disclosure obligations as a lender or a broker. Make sure that what federal and state disclosures are required if you're going to be originating Govy loans. Make sure you understand what all of the disclosures and other documents are that are required to be in a package that is delivered to the borrower. And even though guidelines or statutes and regulations may be drafted in such a way that they do not require a borrower signature, make sure you have the borrower acknowledge receipt, because that will serve as evidence later down the road, if you need to produce that, that the borrower did indeed receive that disclosure. And remember to just routinely check to make sure that disclosures and other documents are appearing in the loan package, a particular loan package during different phases of the origination process. And we didn't go into e-sign or anything like that yet, but there are some disclosure. There is a particular disclosure required under the e-sign act that must be provided to the borrower and agreed to by the borrower before delivering disclosures. So
hey, you know what? That's a great idea. So I have an idea for our next episode with you. We're going to talk e-sign. So I see that coming, because that's a tricky one when it comes to disclosures and timing. I mailed it out. I also got an e-signed, which one counts. We should talk about that and walk through those. So maybe in our next episode with you, we can talk about e-sign. The things I look at too, I agree with all of that. And some of the fundamentals, as I talk about and mentioned it before, is, make sure you're capturing the data. And that's not a given, especially if it's something that has to be captured by a loan officer up front and put into the system. If they're not capturing it, I can't map it, right? So it'll never show up on the disclosure. So make sure you got a process of capturing it. Once you capture it, make sure it goes into a data point that you can actually use and move and move the data where you have to, and make sure it maps to the right place.
That's
once
right.
you know that it's mapping, once you know that it's mapping to the right place, oh good, it's mapping to the disclosure. Well, great, it's mapping to the disclosure, but it's literally in the wrong place. It's on the bottom of the page, when, in the middle of nowhere, when it should be right in the middle of a paragraph. It's not truly mapping and directed correctly. And then ultimately, is the information even correct? So the good news is the ARM loans and the rider and disclosures all make sense, and shows there's a place for a margin. The bad news is the margin showed 0, but hey, at least the 0 is in the right place in the document. That's not a win. So you have to make sure you just really test it. I think spot checking is really what you have to do on any kind of product you have, new states you go into, and keep maintaining. It's what I hear, and partner well with your doc provider, whoever that's going to be. Nobody really manages their own documents. They should use doc providers, in my opinion.
Yeah.
So that works.
I mean, I think that's really important, especially, things happen with technology, correct? There are glitches. Yep. And maybe one thing to consider doing is a spot check every time a doc prep provider or your LOS company update their system, when they provide notification that they'll be updating or upgrading their system for these reasons, maybe unrelated to disclosures, but they could have an indirect impact on disclosures. Right. So it's important to spot check and just make sure that data is appearing where it's supposed to be and calculations are correct, etc. So
it's not automatic. Despite technology, it's not automatic. So you still have to drive the car. We really don't have self-driving cars yet. So we don't have self-generating documents, stated perfectly compliant LOS systems and other doc systems yet. So
yeah, you have to have that awareness so you can apply the brakes when needed.
And steer away from when you're missing a disclosure. Well, very good. Thanks for your time. Like I said, we'll probably pick up on other issues like e-sign. I think it's a good idea you brought that up, and I think that's a key topic that people want to hear. But again, thanks for your time, and thank you everyone for listening to our latest episode of Garris Horn Insights. We hope to see you next time, and thank you everyone.
Thanks, Ray. Thank you. Bye-bye.